Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about killing bears. Cases that should have gone to the Supreme Court of Canada, but didn't. Bryce Cassavant was a conservation officer employed in British Columbia. As a result of a complaint about a bear, Mr. Cassavant was asked in the course of his work as a conservation officer to shoot and kill the bear. When he refused to do so, he was terminated from his employment. He filed a grievance with the Labour Relations Board about the way that he was terminated, which was ultimately determined to be a justifiable termination. Shortly thereafter, Mr. Cassavant took the position that the Labour Board had no ability to hear the case because it did not have jurisdiction over him because he was employed as a special constable at the time, and the complaint and the termination proceedings were subject to the provisions of the Police Act. The Court of Appeal ultimately agreed with Mr. Cassavant and overturned his termination, finding that it wasn't done correctly. This case raises very important issues for all of the different people in Canada that are employed as special constables. There are people employed as special constables for limited purposes of enforcing parking and traffic regulations during public events. Special constables can include bylaw officers, people who are policing railways. There are all sorts of categories of special constables. And this case deserved more attention from the Supreme Court of Canada for the determination over who is subject to the Police Act and who is subject to the ordinary proceedings in relation to labour and unions. The distinction is important because people who are performing policing or quasi-policing functions need certainty about what procedure is going to apply to them. And the decision in this case doesn't make clear that every single special constable is going to be subject to the Police Act, only that Mr. Cassavant was subject to the Police Act in the course of his duties as a special constable in British Columbia. It would have been useful for the Supreme Court of Canada to provide more certainty as to who is a police officer for the purposes of the Police Act. And this goes further than just terminating the employment of somebody who refuses to shoot a bear. This is also about situations involving filing complaints about the conduct of those people when they're working. Do the complaints get made under the Police Act, and are they subject to review like under the Office of the Police Complaints Commissioner? Or are they dealt with in a different manner, using the employer's complaint process? This opens up significant doors for the public to need to know why certain people are constituted police under the Police Act and why some people are not. The Supreme Court of Canada had the opportunity to clarify that, to give the public certainty so that they would know what they're dealing with when they're dealing with people like Mr. Cassavant or like other individuals who are designated as special constables either for limited or for total purposes of enforcement of their duties. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.